Hey y'all, Gary here with Tennessee Stands. Hey, want to talk really quickly today about education and free speech. So some members of my team and I are sort of looking through and reviewing some of the bills that passed this year that became law. And one sort of stood out to me. I'll take you there right now, and it's HB 1269. And this is a bill that we didn't really talk much about during the session, and I knew it was going on, and I fairly, for the most part, supported it, support the premise of the bill, and most Republicans and most of our conservative friends voted for the bill. And I'll tell you why, but then I'll show some concerns that upon reading the bill, there's leaves me with some uncomfortable feelings. So, the bill essentially, and I'll go back there in just a minute, but the bill essentially protects teachers, right, from being sued regarding all of the woke nonsense. In other words, being required to use the preferred pronouns of a student when those pronouns do not match their gender. In other words, it protects the school district and it protects teachers from any liability when a boy comes up to the teacher and demands that they be addressed as a she, her, and the teacher refuses and refers to a biological male as a he. This law, which passed, protects teachers in those instances and keeps them from liability in the court, but unfortunately affirms their right to do so per the First Amendment. And so that's the part that I really want to look at. And again, this is one of those things where you really got to read these bills before you vote yay or nay, because down here in this part where it protects the teachers, we agree. We fully agree and are glad that that part of the bill passed. However, let me just read you part 1 and part 4 here. Now listen to part 1. Teachers and employees of public schools and LEAs do not shed their constitutional rights to freedom of speech or expression while at work. Think about that for a minute. Is that true? Think about the fact that the state, the General Assembly of our state, is affirming a statement saying that teachers, while they're at work, we must protect their free speech rights, and those rights can't be restricted. But can they not be restricted? What if a teacher believes a certain thing and decides to express themselves in a classroom setting in a certain way that might be completely contrary to just basic, simple community standards of decency and understanding, whether that be patriotism or an accurate recounting of history, dealing with things like the 1619 Project or what they might believe about a whole host of social issues. So does a teacher actually have unrestricted free speech rights in the workplace? Or are those rights somehow restricted by state standards when they are in a school setting dealing with education? Let's read this other one, number 4. A teacher or employee of a public school or LEA should never be compelled to affirm a belief with which the teacher or employee disagrees. What about certain academic standards that are prescribed by the state and things that we all agree upon as a community that we are going to teach our students? Shouldn't teachers, shouldn't educators be compelled to at least accept the fact that this is what they teach students, regardless of what they believe? I mean, to me, this is sort of dangerous language. And quite frankly, I'll take you to this website, doesn't agree with the Supreme Court. And this is the issue when you've got legislation being passed that don't necessarily line up with what the Constitution actually says, or at the very least, the most recent court rulings. In 1968, there was a case called Pickering that established that teachers do have First Amendment rights. But that case predominantly dealt with the teacher's freedom of expression outside of the classroom. In other words, if you're an educator and you want to go out and be part of a protest based on something that you believe politically or socially, then you should not be penalized in school for those activities outside of the school. Just because you work for the school doesn't mean you can't exercise your free speech. So I agree with that there, and that's the Pickering decision. But in Hazelwood began to establish in 1988 that schools can regulate school-sponsored speech. In other words, speech within the schools. And this typically dealt with student speech, predominantly, as you can see here, for example, a flat prohibition on profanity in the classroom is reasonably related to the legitimate pedagogical concern of promoting generally accepted social standards. So, the school system certainly has a right to limit or restrict a student's speech within the classroom environment, within the school environment, especially in terms of obscenities and profanities and just everyday common decency in providing a good learning environment in the school. So the Supreme Court affirmed that in 1998. But let's continue. In 2006, in the Garcetti decision, the Supreme Court says that public employees, now it's important to note, this particular decision was not expressly directed at teachers at the academic setting, but the decision simply stated public employees no longer retain First Amendment protection for speech as part of their official duties. So again, there's a difference between someone exercising their free speech out in the public square as a citizen, right, of a free state, versus the requirements placed upon that person within the confines of their work environment, even as a public employee. But especially you would imagine that would apply in the academic setting. And while the Garcetti ruling didn't necessarily have to do with the academic setting, future court decisions have used Garcetti to apply those First Amendment concerns to the academic setting. And so the idea here is that actually, contrary to what we're stating in this new state law that just passed, teachers and students' First Amendment rights can and are restricted to some degree within the confines of the school setting, including curriculum standards that are set forward by the state. Listen, it's the way this works. The state, let me just keep it here with the state of Tennessee. The state of Tennessee has the constitutional authority per our state constitution to prescribe the maintenance and the continuance of a free and public education here in the state of Tennessee, which includes those things that are taught in Tennessee. So that is a concern and a direct duty and power of the state legislature. So this idea that the state needs to protect the free speech rights of teachers, not so much, at least not when it comes to curriculum. So my concern, let me go back to that. Going back to the bill, is that in the name of doing something good, protecting a teacher from having to use these ridiculous pronouns and keeping them from liability for possibly, offending someone, we affirm those things based on their right of expression and freedom of speech and the right to hold their own beliefs. But I just want to be clear, those things that we just affirmed in state law, actually the Supreme Court has not necessarily affirmed. And that knife cuts both ways, right? So we're saying the most woke teacher, that what this affirmation in law says is conversely to what the intent was. The most woke, nonsensical educator that believes all the things, right? Teaching a fundamentally wrong view of the founding of America and everything having to do, whether it be Gay Pride Month or Black Lives Matter or the 1619 Project or transgenderism and pronouns and the meaning of a man and a woman and whether or not we accept the created order and biological truths. We're saying that all of those things now are subject to a freedom of expression and freedom of speech and the right to believe what it is you want to believe. It's incredibly concerning when you put that in the academic setting, especially when you're talking about K through 12, right? Not necessarily in the university setting, even though I've got some concerns there too. But I want to parlay that really quickly as I'm sort of wrapping this up to a local issue in Williamson County in a local school district and how they are dealing with possibly removing 5 books that they agree have objectionable material from the school library. Listen to what one school board member has to say here.
These books were all selected to be part of a classroom discussion on unconventional people, individuals who might be considered as outcast by their community. And that's why these books were brought into the classroom as a optional read. And so a book that, in my opinion, that makes a teenager kind of dive into and recognize that everybody is different and people act based upon their own personal experiences is a valuable piece of literature that's a whole lot deeper than just the subtext or the specific sexual content or bullying content or drug content that's being called out here.
And so here's the problem with the statements that Mr. Mitchell is making in this school board meeting. And really it's a difference of a view on education. There are many of us, like myself, that believe that education really should be about academic mastery, right? How are students doing in terms of reading comprehension? You know, in terms of significant literature, right? Historical literature, math performance, the ability to understand physics and engineering problems and STEM learning and all these different things. That's what education is for. But you have a lot of people like this guy, like this school board member, that actually do accept and believe that, no, it's the school's role to engage in social emotional learning. I mean, one of the big promulgators of SEL here in Tennessee was, I think she still, is the transition on July 1st, so maybe she still is, but she's outgoing Commissioner of Education Penny Schwinn. That was a big stated goal of hers in terms of what she called the Whole Child Initiative. And so we have this new move in our school systems that it's incumbent upon public schools to care for the emotional well-being of children. Well, is it? And listen, so listen to this statement by the same school board member.
We are a public school system, and we have to provide for every student, regardless of what that student's socioeconomic, gender, or background is. We don't get to say we're going to provide curriculum for the 80% who fall into the majority, or we have to provide opportunities for everybody.
And so understand now that as it's the school's role to make sure that they're teaching your child how to think about the world around them and how to have empathy for others and how to treat others and how to care for their emotions. It's the school's job to care for the 20%. Did you hear that? Did you catch the math there? So For all of the nonsense in the schools that we object to, that have historically been objectionable for most families, right? We don't want our kids exposed to sexual innuendo and obscene sexual situations and scenes about rape and all these kinds of things that these kids are finding in our school libraries. But this guy believes that it's appropriate. No, but for the 20% that want that stuff, we've got to take care. We've got to give them what the people want. And for the 80% that don't want that in their schools, well, it's their problem, and they have a burden, right, to now opt their children out of these things. See, the problem is that the school board doesn't have a burden. The government doesn't have a burden to keep obscenities from your child. They are going to provide them to your children. It's you crazy parent that believes that you have a right to teach your child about their emotional well-being and their worldview. You have the problem, and now the burden is on you to opt out. But I want you to also hear this. This is Jay Galbraith and Casey Hall, two more board members in Williamson County. Listen to what they have to say here. Both of these men in a school board meeting both acknowledge that the books in question do indeed have objectionable material. Take a listen.
And so we have the responsibility and the obligation under the law to do these evaluations, and undoubtedly more will come, and we'll have to address books as they come to us. But I truly believe that decisions on individual books without a standard is going to be considered arbitrary in the eyes of the court. I read these books. I think there is, and in my estimation, I think there is objectionable content that's inappropriate for minors.
And I agree, there is some content that would not be appropriate for every student. There are things shared tonight that I can totally understand the objections to. And I would say from our discussion on Thursday, there are effective ways to have discussions with teachers, librarians, and look at the resources available.
So I want to be sure you understand both of these men that are acknowledging to the public in their belief as school board members, as men in the community, that these 5 books in question indeed have objectionable material, at the very least, are not age appropriate for all ages of children in the school system. Yet, they voted to keep the books in the school. Why? Well, because you, the parent, have the burden to opt your children out of the obscenities that the school board now apparently has decided to put in front of your children. The other interesting thing that you hear, especially from Jay Galbraith, is you hear him have an understanding that the school board does have a duty per the state, that state law does in fact inform and require the local school board to have a process in place where they can take these objectionable materials out of school. All right, so there's a mandate from the state to do that. Yet, this local school board refuses to do so. And as you'll see in a minute, because of constitutional concerns, some of the concerns that we just talked about in this bill, which is the problem, understanding who has constitutional rights and who doesn't, and how that applies to how our education system, or what our education system, I should say rather, is putting in front of our children. So I'll keep going. This is Sheila Cleveland, another school board member. This is what she has to say about her personal experience.
And just as a side note, my kids, went here K through 12, and they read those books. And so when I asked them about the certain parts that are controversy, they didn't even give much thought about it, but they loved the book. But they don't remember those explicit parts. It's because it was the book as a whole. They really enjoyed it, and they could not believe that there was questions about removing these books. And so I just had to say that because it was, firsthand experience. Thank you.
So, My children don't even remember the sexually explicit stuff. You know, but they really enjoyed the book. And so it's worth you noting from my personal experience that as your kids are exposed to sexually explicit material, we just want you to know they'll probably forget about the explicit stuff, and they're going to walk away, you know, really enjoying the content that they were able to access in the school. I mean, the rationale here that were being provided by elected members of our school board as to why these materials should remain in front of your children is incredible. And finally, constitutional scholar Jennifer Apria.
We do have the parent right to opt out, so our parents know their kids the best, and if they're too immature to be reading the content, they can opt them out. So I think it's better for constitutionality and liberty to make sure that everyone has access that wants it, and parents have the right to opt out.
And this is, you know, in terms of all this book burning nonsense, and this is where I'll close. The problem is this continuance that we hear from folks that, well, this is a constitutional right, this is a free speech issue. Putting age-inappropriate material in front of children, putting obscenities in front of children, exposing children to sexually explicit content, at the very least content that would not be widely acceptable by a reasonable standard set in a community, that these things would be acceptable for children, that's not a free speech issue. The state of Tennessee, indeed, has a right to regulate those things within the public school system. Just for Ms. Apria's understanding, governments do not have constitutional rights. So to clarify that, the public school system does not have a free speech right. As an employee of a public school system, teachers do not have their own free speech right to exercise their own beliefs and their own desires to promulgate their worldview to your children that happen to exist outside of standards set by the state. Librarians do not have a free speech right to put obscene materials in a library because they think it's okay, especially when those books have content that is outside or contrary, I should say, to state standards. And even children, right, to a certain degree, do not have free speech rights within the confines of a school system to spout profanity or whatever it is they feel they want to spout off at the mouth about in the schools. But we've lost all of this. I mean, education now in the public education sphere, at least, is an absolute free-for-all. I mean, when you can watch a local school board actually say they know, I mean, get this, because we want to talk about, oh, Bill Lee, and we banned CRT, and the legislature passed all these laws. But here's the problem, right? Here's how those things actually function at the local level. You're watching it before your eyes. You have a local school board in a supposedly conservative county, right, that understands they have a state obligation per state law, and they acknowledge that they are looking at objectionable material and material that is not age appropriate. Yet they do nothing. They vote to keep the books in the schools. Number one, because, well, they just don't want to deal with it right now. Number two, well, we think there's some constitutional issues. See, they don't get to determine whether or not there are constitutional issues involved. School board members are required, as well as school administrators are required, to follow the law and follow the standards that are set by the state. But as you can see, that's not happening here in the state of Tennessee. And we've also got legislators espousing things about the First Amendment that are dangerous, quite frankly, and that are not good for protecting our children from predators in public schools. Stay vigilant, stay watchful.